First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have two cases on the docket today. We will not be taking a break between them. The first case is Sisters for Abundant Living versus Florida Department of Agriculture and Consumer Services. It's 22-2100. Mr. Bisbee, are you ready? Okay.
Your Honors, my name is Richard Bisbee. I'm the attorney for the nonprofit corporation Sisters for Abundant Living.
Mr. Bisbee, would you grab that mic and move it just a little there you go.
Sure. I represent Sisters for Abundant Living, which is the appellant in this case. With regards to the argument, I would like to reserve 5 minutes as rebuttal time. To the point, I'd like to bring up 2 points that are the subject of our appeal. The first point is that and what the relief we're asking the court to grant is to vacate the department's July 12, 2022 default final determination because the department failed to establish a clear point of entry for my client to file a notice of challenging the notice of determination that the department issued regarding their participation in the summer food program.
So let's talk about your remedy here. What say we vacate that order? What relief do you actually get?
Well, this ties into another argument that the appellee has made. It's called the mootness argument. Obviously, the program, it's a summer program. It has expired. However, because of the fact that the findings that they've incorporated by reference into their final order touches on or directly attacks the financial credibility of my client, as well as the fact that the client in future applications or in other areas of sponsorship or charitable causes might have to disclose that they were the subject of a denial, as is frequently the case in all types of licensing applications.
How do we know that that's true? Is that in the record somewhere?
No, but I'm making the argument that that is the possibility. But there was no hearing in terms of obviously a factual hearing on this case, but I do believe that just in general with licensing matters or any type of grant, there's usually a question that relates to, have you ever had an application denied? And I think in this case, that's the potential collateral consequence of that defeats this mootness argument. So basically, our argument is that they vacate the default order, and that will be the end of that the remedy at this.
So in their notice of action, as I read it, they found that the Sisters for Abundant Living failed to demonstrate the financial ability to run. They said you didn't come forward with proof rather than you're fiscally irresponsible or anything that would have real collateral consequences. Correct?
That's true, because they defaulted my client and entered a default final order, or determination rather, without having an evidentiary hearing. That was done because they treated a email as the point of entry instead of what the rule requires, is that all pleadings, notice of determination, notice of hearing, and the final determination entered by the department was to be sent by certified mail, return receipt requested. There's no indication.
Well, according to the record, it was sent certified receipt, certified mail, but there was not a return.
It was not returned because they put the wrong address on it. So I found out as I went through the case some more that I made an assumption that it was received, but I was incorrect about that. It was never received. So then they relied on rather than remailing it to comply with their rule, they instead fell back on the email that they served it by email, even though the letter, notice of determination that they issued, doesn't even reference any attempt.
So your position, since the legal service was ineffective, even though the department became aware that Sisters for Abundant Living had actual knowledge, they were still required to go back and send a certified mailing?
I think that I didn't write the rules, they did. And I think if they were going to write the rules, then they need to comply with them. My analogy would be if I filed a civil action with the clerk of court, I got a docketed copy of it, I emailed it to defendant or defendant's counsel, and within 20 days filed a default. I think the same would apply in this case. If they made the rules up, I didn't. And if they're going to have the rules, they need to comply with them. That's all there is to it. To enter a default, when you look at the default itself, that's in the record, you'll notice they go through the tremendous amount of fact-finding and adjudicating certain facts and whatnot about knowledge and lack of knowledge. They touch on this public records request that I made in this case, which, I didn't enter an appearance in the case. I didn't do anything of that nature. I made a public records request.
Do
But they
you
use that.
do you stand by your statement in the brief at page 6 that your client received the email?
Yes, they did. They did.
So they
But-
did know about it
Yes, yes. But as a lawyer,
and still didn't do anything?
well, as a lawyer, my read of their rule, basically, administrative law and general concepts, my read of that was that the return receipt requested type of delivery was when a point of entry started, the deadline started. I think, if they're going to have rules, they need to be very specific as to when that time period starts to run. It doesn't say notice. It says the only type of service that's authorized under that rule is certified mail return
What do you
receipt
think the
request.
purpose of service is?
Well, to establish a clear point of entry, so I don't have to
Well, the
guess.
service itself is to establish notice, to make sure that the person actually gets notice of the action, right?
If it's done correctly, yes. Yes.
And in fact, the agency gave you, or gave your client, even more time. They didn't base it off the original time it was served. They, in some ways, gave a gift and based it on what they knew is the last time that your client had actual knowledge, and gave you more time.
I would argue with, in terms of that, is that you could argue, yes, they gave more time, but, I mean, if they have a rule, I think that the law requires them to comply with their rule. I think that's the case I cited to that effect was the Vantage Healthcare Corp. And they didn't do that in this case. They didn't serve it properly, and they should have. And whether they had more time or not, I don't think is germane to, or that does not relieve the department of their legal obligations in this particular case. And the other thing I think that's important to note is, again, going to the mootness issue, it's not moot because there are some legal collateral consequences on my client provided by virtue of the fact that they've entered findings about my client's financial wherewithal.
Is this case under the APA?
Well, that's an interesting question. There's a portion of this case that is not subject to the APA. That's in the statute, the governing statute, Florida statute, and then there's other portions that are. But in terms of this procedure, the department promulgated this Rule 5P-1.002 specific to fill that gap in terms of the procedures. And again, one thing they could have done.
I'm sorry, but the reason I ask is when the court ordered you to show cause why the case shouldn't be dismissed because you didn't have a record submitted, your response was, we don't have to submit a record because this is not under the APA.
Well,
So if it's not under the APA, if this is not an appeal under the APA, which if it were, then there'd be a record required, then what is the authority to have this appeal in the first place?
Well,
And
the-
why do you cite so often to 120.68?
well, I mean, first of all, the notice of action, as well as all the pleadings that the department filed, their notice of rights refers to the Administrative Procedures Act, Chapter 120, in terms of, I mean, that's the forum that they have told myself and other litigants in the past that you have to seek. In terms of the remedies, this court does have the remedies set aside, a final order. Now, I did notice that the department very late filed a notice of supplemental authority, and it might touch on the issue you're raising, but in terms of this jurisdictional argument. But what I would argue is that, or make an or tennis motion, that should be stricken because the issue that they're raising in that notice of supplemental authority was not briefed, and it's not part of the appeal. And I think that at this point, it's not proper.
Well, let's assume we're just talking about the Florida statute for a second, and 120.68 and the Florida Rules of Appellate Procedure.
Right.
There's no record on appeal here, just an appendix, and your response to why the appeal should not be dismissed was, okay, this is not under the APA, so under 9190, a record is not required, it's just an appendix. Which, okay, if that's your position, that's your position. But then you have to identify, well, what is the source of our authority for hearing this appeal in the first place if it's not under the APA? It can't be 120.68 under your argument then. It has to be something else.
Well, I mean, I know that other cases similar to this have been argued before other DCAs without that jurisdictional issue raised.
Well, I was on the panel that asked that question.
Right. But I think, in terms of the appendix was required under the applicable rules because this was a matter involved a federal program. And so on that, there was a motion to strike the appendix or not provide a record. We responded to that, and the court ultimately dismissed the order to show cause to reject the appendix. So it was particular to this type of case, and that's why there's an appendix. There's not a formal record on appeal. It's just the way this procedural rule worked.
Let me bring you back to, for a moment, to the notice issue. So the rule requires certified mail, return receipt requested. And the department says, well, we did send it certified mail. Does it matter who's responsible for the incorrect address?
Well, clearly, if the department's mailing something, there's a duty on their part, particularly a legally significant document, to correctly address it and mail it. And that's their burden. And if they don't do it, then they need to correct that. I mean, I think that's the way it should work from a legal standpoint. In terms of a point of entry, I think that that's how points of entry are established, and everyone's on the same playing field, level playing field. The department can, say, well, we're going to disregard that, and we're going to count this day, but there has to be some clarity in terms of someone calculating when something is due. It doesn't say.
Right. Well, my question is more specifically, let's say you you accidentally provide the incorrect address to the department, and they send it to the address that you provided. They certify mail, return receipt requested, and but it doesn't get to you. Does it matter who's responsible for the incorrect address?
Well, in this particular case, that's a fact that's not within the record. They had the correct address because this involved an application submitted by my client to the department. Obviously, the correct address was provided to them. There's no dispute in the record that there was an incorrect address provided by my client. And they had dealt with this client repetitively over the years for this particular program. This is the only year that.
So do we have that in the record before us?
That what their address was?
Yes.
Well, I mean, I think that there would be.
My concern is you're making a lot of representations about things that happened, and I'm looking for a record before us that demonstrates these things.
Well, I mean, in the request for appeal that I filed, I put the correct address down. That's in the record. In the notice of administrative appeal, I believe there's a correct address. I mean, it's pretty clear, I think, to me that the department is the one that has the duty to correctly address the document that's of legal significance to the correct address. And there's no issue, there's no argument in the briefs that I could see from the department that they didn't.
Let me caution you, you are well into your rebuttal.
Oh, yes.
Okay.
Thank you.
I will give you an additional 2 minutes because we started asking questions right at the end. And Ms. Shaw, you will have an additional 2 minutes if you need to use it for some reason.
Just in summation on my argument, Your Honor, I believe that.
Okay, well, your clock's running.
Okay, just believe that the court should vacate the default final determination. I think that's a just and fair thing to do in this case. And again, I don't believe the case is moot. Thank you.
Good morning. May it please the court. I'm Darby Shaw for the Department of Agriculture and Consumer Services. It's the department's position that the notice of action denying the appellant's application was served on May 29th, 2022 by email. Because they actually received the notice of action, the default final determination on June 10th was proper. We received appellant's hearing request on June 13th, which is past the 10 days provided in rule to submit your request for hearing. The appellant argues that the clock should never have started because they received the notice by email, never by certified mail. This is despite having stated in their request for hearing that they received the certified mail on June 1st. The department's rule only requires that we send the notice of action by certified mail, not that it be received as such. Appellant makes much of the fact that the suite number was left off of the address for the certified mail and was eventually returned unclaimed.
What
But-
about my question? Is this under the APA or is it not?
Well, certainly we can talk about jurisdiction.
I mean, it sounds like the agency took the position it was not, and that's what they told Mr. Bisbee, and that's why a record of appeal was not sent. But why wasn't it sent? Why is this not under the APA, or what's the department's position on this?
So this question has been raised in another case that's pending before the court, and there's been a number of internal discussions, I can assure you, about whether this falls under 120.
I asked the question, right, in the last
Absolutely.
case, yeah.
We've been operating under the presumption that this is a 126.8 case, but if you look at our authority in Chapter 595, you see that we're exempted specifically from 125.6.9 and 5.7. So the question boils down to, well, then does that make our final determination final agency action for purposes of being a 126.8 action and giving this court jurisdiction to be before you? After having reviewed.
And the Florida Constitution provides that we have review of administrative action as provided by general law, right?
Correct.
Okay, and my reading of the statutes and the briefs, that y'all have a rule that provides for appeals to the district court. Is that general law?
Well, I believe that's the ultimate question that has to be decided is this final agency action? Is a final determination entered by a department hearing officer? Final agency action is contemplated by Chapter 120. And we believe that there's a legitimate argument that it's not. It's not a final order as defined.
Sure, but the difference between the Ninja Academy case and this one is, this one, it looks like you do have an order from the agency as it purports to be final agency action that's signed by the director, unless you're taking the position that the director is not an agency head for purposes of conducting final agency action.
I think the issues are the same.
I mean, does it matter? I seriously don't know what the internal structure is. The person that signed the order in this case appears to be akin to an agency head. It's different from a hearing officer, but maybe that's wrong.
I would just say that the question, it's still a final determination. It's a default final determination, and the way our procedure is set up, either a hearing officer or the director enters the default, but either way, it's a department employee. And I hate to go down the road of, advocating that this isn't 126.8 because I understand that's what's in our rules, but I think this discussion has needed to be had because it was raised by the court in the previous case. It's also consistent with what we have recently found in federal law, having to do with applying a state's APA procedure to the federal procedure for the summer food service program. And those are the Ohio cases that were submitted with our notice of supplemental authority. The court there found that it could not just engraft the state's APA procedures into the process. And that interpretation is actually, would lead to a more tenable process for the department, because otherwise we might have a situation where the department receives a result from the District Court of Appeal that is at odds with what the directives from the USDA are. Granted, that's more likely to happen in a case where we're denying a reimbursement or trying to reclaim a reimbursement. So if the court were to say, department, no, you should have paid this particular sponsor, but the USDA disagrees, that sort of puts us between a rock and a hard place. So for that reason, what would be a more reasonable outcome would be to have the sponsor proceed under 7 CFR 22518, which is cited in those Ohio cases, and allows a sponsor to request a settlement or determination of claims from the USDA secretary. And then that determination can then go through the federal APA process.
What is so one of the differences between the Ninja Academy order and the one here is this one, it has the commissioner at the bottom and the director of the division signing it. Is the director of the division, when she signs this order, is she the agency head for purposes of managing this program?
She is, but I would argue that a hearing officer would have the same authority as the division director,
That's why the division director signed this one as opposed to a hearing officer.
because we didn't reach a hearing in this case.
Right. So, but under the school lunch program references, doesn't say the entire APA, notwithstanding. It references very specific sections, and those sections happen to deal with hearings, factual disputes, those kinds of things, presumably because under the federal law and the federal rules that you're mimicking, it contemplates a different process for conducting hearings. But that doesn't mean necessarily that the APA doesn't apply if one can identify final agency action somewhere, right?
That's right.
But is it the department's position now that this order is not considered final agency action because it could have been easily signed by a hearing officer? It just happened to be, is it Ms. Collin?
Yes, the department's position is that under the definitions in Chapter 120, the final determination may not be a final agency action as contemplated by 126.8. And that is the case for both a final order like the Ninja Academy case and a default final order.
So Ms. Collin was
Sorry,
basically.
final determination.
Sure. So Ms. Collin was basically the one that happened to be around when this thing needed to be signed, but it could have been signed by, I wouldn't say anyone, but someone that has the ability to, I guess, conduct hearings for the department or the division?
Right, well, anyone who's given that authority by the commissioner, which would also be true for our hearing officer. He serves at the pleasure of the commissioner just as much as the division director. If I may, I'll get back to the service question that's
So
at issue.
I'm sorry, so then is it, if the department's position then is if this is not final agency action, does that mean that we don't have jurisdiction to consider this appeal?
Not under 126.8.
Sure. Is there another provision that you're aware of that would give us authority to consider this appeal?
Not that I'm particularly aware of.
In general
There-
law, not your rule, but in
Right.
a law
There-
passed by the legislature.
There may be certiorari jurisdiction for the court to consider this case, but we believe that the process under the federal law, under 22518, that allows that application to the secretary is the more appropriate process.
But your argument is that the the rule gives us jurisdiction because the statute delegated the authority for the department to come up with the appellate procedure, correct?
That's the assumption we've operated under in the past.
The idea that this is not a final agency action is a new issue, right? I mean, the federal law allows the state agency to create an appellate procedure, and that has been done, and that has designated this court as the court to review for appellate purposes final agency actions under this rule.
That's right.
Well, if that's the case, where's the record on appeal that's required?
Well, because this isn't, well, there's sort of two ways of looking at it. How we've done it in the past, which is what we were operating under to get to this point, and why we looked at the appellate rules of procedure, which say if your agency action doesn't fall under 120, then you file the appendix rather than a record. We looked at that and said, well, our hearing would not fall under the APA, which is what gets us to the DCA. And so in that case, there's no record to be filed. I'm not sure that answered your question.
It's all right. No, I'll defer
I'd be happy to try
others.
again.
Well, I'm just trying to, maybe this gets to another question. Why does there have to be a right to an appeal in this case?
I'm sorry?
Why does there have to be a right to an appeal in this case at all? Like, why the struggle to find a way to get here? I frankly don't understand what even the right is that's at stake here. Like, the underlying right. I'm assuming the department doesn't take the position that Sisters Academy has a right to, this license or to be one of the vendors.
Right. I would point out that this is not an entitlement program. We're talking about a reimbursement program. So I would agree that there is not the same sort of right at stake. That being said, in an effort to afford due process, we want to make sure that we've provided that.
Well, but due process doesn't hang out there in the ether by itself. There has to be a property interest or a liberty interest at stake to be deprived of for due process to enter the picture. So what right are we talking about that's at stake, that due process is, as you say, required?
Well, I believe when you submit an application, that comes with a certain amount of administrative rights if it's denied.
Do you,
similarly,
though? Which right, though? We're not under the APA, apparently, so can't look to Chapter 120 for those administrative rights. What right are we talking about? I mean, the federal government has given the department a bunch of money to administer, and the department has a responsibility to find the best way to administer that money consistent with whatever the objectives are of the program. The department does the best it can to do that, and it solicits people, entities to come in and do that job, and the agency looks at those and tries to vet it to do the best job possible. Where does the right to any of that enter in? Like any of these entities applying, where does their right enter into any of this?
well, when the applicant goes through the process and the effort to apply, we believe an explanation is owed if that application is denied. I don't know that they certainly don't have a right per se to participate in the program, but similar to like a licensing application, if that's something that's denied, there's certain rights that come with that as far as having a hearing and an opportunity to show that you were actually eligible. So I believe that would.
Well, licensing is tied to livelihood. This is not
Right.
a livelihood issue. This is an administration of a federal fund that's been given to the state to then administer on behalf of the federal government. And the agency, from what I can tell, provided an explanation as to why Sisters Academy was not going to be approved. So again, I'm not criticizing the agent, I'm just trying to understand why the agency is struggling so much to find an avenue for an appeal if there isn't one that exists necessarily.
Well, I wouldn't necessarily disagree with you. I think that just from a government standpoint, it doesn't quite set well with the agency to not provide that sort of some amount of process when it denies an application of this nature. Granted, it's not a property interest, like you said. If the
Well,
court
don't you think that
finds-
every applicant is entitled to a fair application of the rules in the same way that any other applicant would be entitled?
Certainly.
So shouldn't an applicant be protected from arbitrary agency action?
Yes. Again, I'm trying to avoid putting this under 120, but I think the same principle would apply, yes.
Do you have anything you'd like to say with regard to the service of the issue here?
Sure. Well, I would just, again, point out that service was actually received by the respondent, and therefore due process was had. They had an opportunity to respond, and they didn't. Moreover, this case, were it to be remanded and go to hearing, the summer food service program ended in August, so there's really no remedy to be had here. And any future applications or damage, to their ability to participate in other unknown programs is pretty speculative at best. So if the court does find that it has jurisdiction in this matter, we believe that there's been no denial of due process, and the default should be affirmed. Again, the case is moot, and the default final determination was properly entered after service on appellant. Thank you.
I'll be very brief, Your Honors. This issue as to the jurisdictional aspects that are being raised here, I think those are touched upon in the, again, notice of supplemental authority. Obviously, that issue's not been briefed. However, I would welcome the opportunity to provide a supplemental brief if the court wishes to open that.
But you were given an opportunity when the court entered an order to show cause why this thing shouldn't be dismissed because you didn't have a record of appeal filed. Your response was, this is not under the APA.
Now, my response was that I don't think I said specifically that. I said that this rule specifically provides such and such in a case of this nature. I mean, obviously, in terms of the rule that allows the filing of a appendix, I don't believe it says anything specifically about jurisdiction, federal jurisdiction, anything of that nature. However, I'm more than welcome to brief that issue if the court wishes. Right now, all we have in front of us is their notice of supplemental authority with some cases, one in Ohio and another one, but obviously I think that's argument. I think that's not been briefed beforehand, so I think that would be it's basically outside the record before this court at this point. The other thing, too, I mean, we're talking about the APA, we're talking about the federal regulations. One point I'd like to raise is that, or note that under the federal regulations that govern this program, the department easily could have adopted their notice regulation, which basically says that they would can serve the notice of action by certified mail, by email, by any number of means. They chose not to do that, and they instead restricted themselves to certified mail return receipt requested.
If your client were given relief, what would that hearing look like? What would be at stake in the, I guess, what you would characterize as the name-clearing hearing?
That's it right now because the program has expired. I mean, my client every year provides meals to the destitute children in that area. It's not a money-making enterprise by any means. It's a charitable event and exercise. And,
so the department would conduct a hearing, have a hearing officer, have a hearing, there would be evidence presented and that kind of thing, and the hearing officer would enter an order saying that your client was financially able at the time?
We would have.
And then there would be nothing that would follow from that because the program is over.
We would have to, obviously, if their challenge is you're not financially, don't have the financial capability, et cetera. Obviously, at a hearing, that would be the disputed issue. We would have to present evidence, and we were able to do that regarding that they were financially capable.
And then what would that determination be? I mean, the hearing officer would just enter an order.
He could disregard our evidence, and frankly, that frequently happens in these cases. But
Even if the hearing officer agreed with you.
then we should be able to be approved under the program.
But you wouldn't, because the program's over.
That's true, because of the time period involved in the
Right.
appellate process. You're right. I mean, that's why I'm saying the relief right now is to clear the record, their record, personal record, that have been financially reckless, et cetera, et cetera, et cetera. That's really the only relief we're seeking from the
Did they
court.
find you were financially reckless?
They made various findings about the financial
And
nature.
I know I'm asking you about a record that doesn't exist, but,
Well, I mean,
it's
they
not
said-
before us.
In the order that they cited, that they relied on, the notice of action, they said there were material inaccuracies, that financial capability of this entity was not demonstrated. I think those are, in terms of material inaccuracies in their financial statements, that has some stigma attached to it. And frankly, that's what I'm here today asking the court
Well,
to do.
failure to prove up the financials is not the same thing as finding you were financially irresponsible.
Not responsible, financial, the wording was financial inaccuracies, basically. That's what they used in the notice of action, that there were financial inaccuracy in their financial documentation that they supplied to the department, which is something we would challenge, and that they didn't demonstrate they were financially capable of administering the program.
Okay, you were over time right now.
Appreciate it, Judge.
All right, thank
Thank
you.
you.
Thank you, counsel, for your arguments. This case will be submitted, and we'll let y'all clear on out and allow the next crew to come up. Okay, the next case is Nicole Morris versus Capital City Bank. It's 22-1365, and there's been allotted 20 minutes per side. Mr. Martin, are you ready to proceed?
I am, Your Honor.
You may proceed then.
Thank you. And may it please the Court. My name is Jonathan Martin, and I represent the appellant Nicole Morris. I'd like to request 5 minutes for rebuttal.
Okay.
Thank you. This Court should reverse the trial court's order granting summary judgment for 2 reasons. First, contrary to the bank's tipsy coachman argument in its answer brief, the trial court correctly concluded that Ms. Morris, an invitee, was owed a duty by the bank to reasonably maintain the property free of dangerous conditions and warn her of the same. And second, the trial court erred in granting summary judgment because Morris presented sufficient evidence to raise a genuine issue of material fact as to whether the bank had actual or constructive knowledge of the dangerous condition. As to the duty issue, in this case, the bank argues that notwithstanding her invitee status, that the dangerous condition was either so open or not inherently dangerous, or so open and obvious that any reasonable person would have necessarily noticed and avoided it, such that the duty of the bank should be discharged. But both of those circumstances don't apply in this case, as it's dealing with a transitory foreign substance. And this Court...
Why do you think it's a transitory foreign substance?
So because it is oil that is located on the floor, just like, for example, water is something that's commonly located in general on the floor of stores because people spill things, but the court still finds that
Yeah, but we
they're-
don't have a floor here. We have an outside premises. It's a parking lot or a drive-through and an ATM. Is there a difference, or do you think an oil slick or spill in a parking lot is the same as a banana peel in a grocery store?
I would say that it's analogous, and there's also the cases where the rainfall has fallen by the threshold of the store, and so whether it's just inside the store or just outside the store, it still could be a dangerous condition if, for example, they weren't put up the signpost of that
Sure.
sort of.
I'm not suggesting that it's not a dangerous condition. I'm asking why you think 7680755 applies at all in this case, as opposed to just a dangerous condition on the premises. And I ask that question for two reasons. One, it's transitory substance, and I'm wondering why you think an oil slick, which, you know, it happened, there's lots of debris, whatever else on the premises, why that's the same as a banana peel that can appear abruptly or suddenly and then disappear, which is the definition of transitory. And the other reason is the statute talks about in a business establishment, and it doesn't strike me as this is a situation where it was inside anything. So with that, why do you think the statute applies, and does it make a difference?
Honestly, Your Honor, if the statute doesn't apply, it would be actually helpful for Morris's case because there wouldn't be any limitation. It would just be normal, regular negligence, and there wouldn't be the constructive versus actual knowledge requirement from the statute. But the case law would likely still require a showing of actual or constructive knowledge in any event. So I don't think it would affect the outcome of the case. But there have been many cases, so even the Grimes decision, for example, where the rebar was tripped over, it's not a transitory substance, but it was still the business establishment, even though it was outside. And so I think that there have been parking lot cases. There was the one with the gouge where they tripped on the parking lot, and they still found that it was on the business premises. But I don't think whether the statute applies, it certainly wouldn't hurt the appellant's case.
Right, but, and so, I mean, related to that, why isn't it enough that the fact that the bank was power washing the outside on a regular basis every 6 months or so, is that enough to implicate 7680755 1B? Or just generally the idea of the entity was on notice in some way of the condition of the premises being collecting grime, debris, those kinds of things from time to time?
Yes, I believe, not to argue against myself, but I think they cited Johnson versus Cumberland Gulf Co. Group for the argument that general knowledge of like oil, for example, or dips. I think there it was a gas station where they had generally understood that there might be oil or potholes in the area. And the court, that was the Middle District, had found that that was insufficient, so we didn't make that argument.
The Middle District, is that a DCA or is that a federal?
No,
court?
just a federal court decision.
Why should we care about what the Middle District of Florida says?
Well, I think this court absolutely should not care about what the Middle District says. And so certainly it's possible that it could find that it's a reoccurring issue, that there could be oil in the, now in this case, Ms. Angela Wilson did testify that she wasn't aware of there ever being a slip and fall or oil in the area before, so it wasn't something that, an argument that we made in this case, but I suppose, as Your Honor mentions, the fact that they do know that oil has to be cleaned from time to time because of this reoccurring cycle could be some evidence.
Is that what it shows? Does pressure washing concrete show that they know that oil spills in this location and it's a dangerous condition?
I would argue that it could be argued to show that, but I would argue that I agree it is not a strong showing. And Morris didn't take that route here, going instead for the length of time and then, of course, the actual knowledge here.
Well, at page 12 of Kathleen Dawson's deposition, when asked about what the purpose of the pressure washing was, dirt, algae, mold, buildup of mildew, oil spots that may be present at the time of the pressure washing, bugs, spider webs, things along those lines?
Yes, and so I do believe there is a theory for the reoccurring argument, and certainly if this court were to adopt that as a material disputed fact, obviously the appellant would not oppose such a holding. But in addition to that, this court could also find, as the appellant has argued, that there is constructive knowledge based on the length of time and the actual knowledge, because one inference can be drawn from the inspection facts and the facts of the day of that oil is what necessitated the power washing 4 days prior. And so if the oil existed for 4 days, that would create a reasonable jury question as to whether it was there for a sufficiently long period of time, or, since Ms. Dawson is a bank employee, that she actually knew it. And so those
Does it make any difference that the bank didn't have up signage that says no pedestrians? You know, because it doesn't seem unreasonable to me that a place where cars idle to transact their business might have oil underneath where the car is idle.
Right, and so in this instance, that goes a lot to the Grimes decisions and the landscaping cases, including the Grimes decisions, the one where they tripped over the rebar, where certainly one would not expect and they did not inspect people to walk through the landscaping areas, but they had knowledge that people did do it anyway. And so the case law is quite clear that the duty remains even if somebody walks in an area not subjectively intended for walking. The Savignac case where the individual jumped off a bridge, certainly that was not intended, and they, I don't believe they had signs, don't jump off the bridge, but presumably that was not a subjective intended use, but because the property owner is aware that people do it, the duty nonetheless attaches. And so I don't think, I think that it would give them a stronger case to show their subjective intent if they had a sign that said do not walk. But again, the case law is clear that objectively, if they are aware that people are doing it, then that's enough for the duty to attach. I suppose it might raise a assumption of the risk argument that I haven't briefed, but luckily that there's fact pattern isn't present.
Angela Wilson works for Capital City Bank, is that right?
Correct.
And she testified in her deposition at page 22, or 310 in the record, that she and her husband have done the same thing that Ms. Morris did.
Yes, and for the same reason,
Right.
because her vehicle she believed was too large, she walks in there and she specifically testified that she's aware that customers do use it. I believe it's almost every other week. She walks up to the ATM and uses it for that purpose. In this
And again,
case,
we're not trying to try the case here. The question is, did Ms. Morris submit enough evidence to show that she has a case, right?
correct, Your Honor, yes. And the following
Go ahead and finish your
Sorry.
thought.
In the following four items of evidence, these are all four pieces of evidence that are proven by, or excuse me, are supported by direct evidence, and then collectively, they allow for the one single inference, which is that oil necessitated the need for power washing. And so first, Ms. Dawson inspected the area 4 days prior and determined that the parking lot needed attention and that the drive-through area needed power washing. Second, she testified that one of the reasons for power washing is to remove oil. Third, lo and behold, there was in fact oil on the floor in the drive-through lane. And then fourth, the indisputed evidence is that the power washing did not occur during those 4 days. And of course, motor oil does not evaporate like water does, and thus would necessarily be present over the course of the 4 days. And so collectively, from those underlying pieces of evidence, which are proven, or I should say supported by direct evidence, allows the single inference that the oil existed there for 4 days. And so that single inference is what allows a jury to find either that Ms. Dawson knew, and therefore it's actual knowledge, or if it was there for 4 days, whether that was a sufficiently long period of time such that the bank should have cleaned the oil spill.
How would you generally characterize Ms. Morris's cause of action or the theory of her suit? Just generally speaking, what's the
negligence.
basis of her suit?
Negligence
And negligence of whom?
against the property owner of the bank.
Right. And it's based on the premises and the condition of the premises, is that right?
Correct, yes. Failure to warn and failure to reasonably maintain the premises.
And does Ms. Morris have an inviolate right to a trial by jury under the Florida Constitution?
Yes, Your Honor.
All right. And what effect do you think that the new rule might have on her right as applied in this case? The summary judgment rule and what the judge actually did in this case?
Right, and so in this case, which is, I think, going to happen a lot of times when we have this new federal rule applying, in state court, the trial judge, in its attempt to try to determine whether the affirmative evidence the plaintiff has presented was, above the scintilla of evidence, as the federal courts call it, ended up weighing the evidence himself and determining that based on the competing inferences that the bank raised, such as Ms. Dawson's hypothetical suggestions that maybe mold or algae or something else could have done it, weighed those competing inferences against Morris's reasonable inference that oil necessitated the power washing, and decided that she didn't conclusively prove her case at summary judgment, which of course is not the federal standard. And so this would be a good opportunity for this court to clarify the record in that regard, and that summary judgment is not trial by affidavit and trial by deposition. And so the competing inferences in this case, not only is it the case that both in federal and in previous Florida jurisprudence, even equally reasonable competing inferences are reason to deny summary judgment, not to grant it. But here, not only is Morris's inference that oil necessitated the power washing a reasonable inference, it is the most reasonable inference, if not the only reasonable inference.
Why does it need to be that specific?
What's that?
Why does it need to be that specific? Is it because you're tying your case specifically to the knowledge, either actual or constructive, of this particular oil slick, as opposed to a more general question of, was the bank on notice that its parking lot accumulates grime, debris, oil, all kinds of other stuff that requires from time to time a cleaning? And as it turns out, your client slipped on one of those, I don't know, hazards or whatever. Does it have to be specific to that particular oil slick, the knowledge part, or can it be a knowledge of the condition of the premises?
It does not have to be that specific with respect to the reoccurrence theory, which Morris did not pursue primarily. But it
Why
would.
not?
Well, because the reoccurrence is just generally knowledgeable that a particular kind of incident occurs and reoccurs, and if it did occur again, then that would be sufficient evidence under the reoccurrence theory. So it does not have to be specific under the reoccurrence theory.
Right, but that's not what your client is pursuing here?
Well, we haven't primarily pursued it. In the answer brief, they did argue that we conceded the reoccurrence theory, and in the reply brief, we clarified that we haven't conceded it, though it isn't primarily what we are pursuing on this appeal.
And do you, how does that relate to some sort of preservation argument? Is it enough for purposes of summary judgment that your client present, here's my theory, it's a negligence theory, premises liability, conditions of the premises, in response to a summary judgment motion, you go down one avenue, but if the evidence suggests some other basis to get to a jury, do you waive that theory if you don't assert it in opposition to summary judgment motion?
I think it depends on the facts of the case, and because I didn't review the case before this oral argument for the purpose of identifying the waiver issue as to the reoccurrence, I'd really have to review it myself. So I think it depends. Because, for example, there's so many cases that you read and you see that they start with, the plaintiff presents the actual knowledge issue and the constructive knowledge issue as to reoccurrence, but it does not argue length of time. And so in those instances, it seems to be pretty clear what the plaintiffs are arguing, and so I think it would just depend on how it was argued below. I see that I have run into my rebuttal time, so I will save that for rebuttal. Thank you, Your Honors.
May it please the court. Good morning. My name is Thomas Valdez, and I represent Capital City Bank in this case. The final summary judgment in the bank's favor should be affirmed for two reasons. First, because the bank had no duty to maintain the drive-through ATM at issue in this case, an area that is not meant for walking in reasonably safe condition for pedestrian use. And that is borne out by our discussion of Wolf versus Sam's Club, 4th District case from 2014, Dampier v. Morgan, the 5th District case from 2012, Taylor v. Universal, the 5th District case from 2001. And at the core of these cases or one of the things at the core of these cases is the observation, the correct observation, that there is a line of cases prior to these cases that have held that there's no liability for falls that occur on surfaces that were not designed for walking. Surfaces like planters.
The bank, through its employees, had knowledge of people often walking up to that ATM even though it was in a drive-through lane.
There was evidence in the record that people would sometimes walk up to the drive-through, but there was no evidence of any. There was no evidence there were any prior falls, and so that doesn't get around around the problem. And this issue is actually.
But there is evidence that. Oh.
I'm sorry. This issue is actually discussed in Wolf v. Sam's Club, because in Wolf v. Sam's Club, the record showed that Sam's Club was aware that people sometimes walk through these planting beds, and they had even had 2 instances where people had tripped, and they said, well, that's not enough to create a duty, because we're talking about an area where people walked into by their own choice, and they walked into that area and knew or should have known that there were potential trip hazards in that area. They even say in the case law that the precise nature of the ultimate cause of the trip or slip and fall need not be observed, because in areas like planting beds, planters, like drive-throughs, the plaintiff knows or should know that there are potential trip hazards here. And anyone who's ever been through a drive-through of any kind knows that cars go through there all day long. And that
Is it a legal question or a fact question?
I'm sorry, Your Honor?
Is it a legal question or a fact question? Are you saying that as a matter of law, your client has no duty to maintain the safety of that drive-through, that ATM area, except for cars, I guess?
But in essence, yes, Your Honor. I'm saying that this is meant to be used by cars, and my client has a duty to maintain it in reasonable order for the purpose for which it's to be used. And in fact, the record shows that they were doing that by having regular inspections, having the area pressure washed.
Why? Why do you need to pressure wash for cars?
You have to pressure wash for the reason that Ms. Kathleen Dawson talked about, because there are any number of, some of these are cosmetic reasons, and some of them are potentially safety reasons. There could be mold, there could be mildew, there could be bugs, there could be leaks from cars. So you have to maintain the premises in reasonably safe condition, and cosmetically, you don't want your drive-through looking terribly. This is a place of business, so they're doing this on a very regular basis. And I'd like to make a point. We keep talking about this, or people keep talking about this being oil. The record shows that the plaintiff testified this was an oily substance. She didn't know what it was, and it's.
But we do know that she slipped on it, and it wasn't supposed to be there.
We do know that she slipped. We do know that it's the type of substance that you might expect to find. You should expect to find in an area that's meant for cars to drive through. We know that she said it was an oily substance, and that when she took a picture of it, the only thing she saw was a slide where her foot had slid through the substance. She didn't testify there were any tire tracks. She didn't testify there was any dirt or grit or grime or anything that suggested that oily substance had been present for any length of time under any of the traditional measures that the case law talks about here in Florida.
Why does she not have a constitutional right to get to a jury on the question of, based on the evidence that she did submit in opposition to your client's motion, on the question of whether, under the circumstances here, where it's the only bank in the county, it's the only branch in the county, and it's got one ATM, and it's a drive-through. It's not there's no walk-up ATM, and people who want to come and get their money out, and your bank knows that people are using the ATM as a walk-up. Why? I mean, maybe you win in front of a jury, but why can't the jury hear this evidence and determine whether, under these circumstances, Capital City Bank undertook a higher obligation to maintain the premises or keep people from going up to the ATM?
Well, Your Honor, this gets to the second point, and the point of notice. I mean, I think the case law establishes, as I've set out, that there's no duty here. There should be no liability here. But there's no evidence of notice of oil in the area of the ATM. They said people have used this, but no one has ever slipped here before. Every employee said.
Do you need to have a slip to have notice of debris and oil and other stuff in this area, in the premises?
Well, this is when we talk about, we get to that foreign transitory substance analysis or the premises liability analysis that says a landowner must have actual or constructive notice of the hazard. And the hazard, for the plaintiff's purposes, has always been the oil that she tripped on. And as I said, they cannot establish it was there for any length of time, any length of time that would have imposed a duty on my client. It would be pure speculation on these facts where we have liquid. The only mark on it is her slipping on it. There's dirt and grime maybe in different areas. There's no dirt or grime in this substance. If this was on a grocery store floor or a shopping center floor or any other sidewalk floor, we would look at the same thing. Has it been there for a sufficient length of time? The bank employees testified they didn't see it. They were not aware of it. The plaintiff testified that she didn't see it. She testified, though, that the condition of it was such that, based on at least traditional factors, it had not been there for any sufficient length of time, any length of time that, as a matter of law, would have put my client on constructive notice of the particular oil spot on which she slipped. And there was no evidence of recurrence of this issue in the particular area, even though the plaintiff should have assumed, walking into the area, that there's a potential of this sort of thing. But what she slipped on, and the cases on this are legion. So if we say that
From this court?
From every district court in Florida that I'm aware of, that say that where you can't establish that a substance, an unknown substance, a transitory substance, has been on the ground for a sufficient period of time that the business knew or should have known of it so that they could remedy it.
Well, transitory suggests temporary. I mean, in fact, that is the definition of transitory. At what point does a substance stop being transitory?
It's an interesting question, Your Honor. I think if a substance, and I'm not exactly sure how to answer it, because in the cases that we've dealt with, the substances hit the ground and they're cleaned up within a certain period of time. I mean,
Sure, because they typically happen inside a building, usually a grocery store or a Walmart or something like that, where the thing appears, and the question is well, how long was it there, and did the premises owner have enough time to do something about it?
And that's exactly the question that was raised here. That's the theory that they've pursued. They've pursued the theory that it was there long enough, and in fact, their theory throughout this has been that that Kathleen Dawson, whatever she observed 4 days prior when she said, hey, we should pressure wash, is the exact same oil spot on which Ms. Morris slipped. And the testimony just doesn't bear that out. That would be wild speculation. The testimony shows that this wasn't there for very long because it wasn't dirty. It wasn't grimy. To the extent that they're suggesting that after hours the bank should have done something differently. They're suggesting a negligent mode of operation theory, and that's something that Florida law doesn't recognize anymore. And the
Now, you say it doesn't recognize it because the statute was repealed?
because the statute, well, we had the new statute and then the
Sure.
and then the case law. The case law said that there isn't a negligent mode of operation anymore. But this is not like
For
rebar.
outside and, for both outside and inside the,
I think that's the position that both sides have taken in the case, that's the foreign transitory substance statute applies here. I think it absolutely does. This is the kind of scenario that it was meant to apply to, particularly on these facts where we have a liquid. And even if you looked at it outside the scope of the statute, they would still have to show actual or constructive notice on the part of the bank, and that the bank somehow, did something wrong in not cleaning this up. If this were to go to a jury, this is completely speculative. That could have been there for 5 minutes before the plaintiff got there, or 5 minutes after the bank closed. Nobody at the bank saw it, so there's no actual notice. All the indicators of constructive notice are the things that would make constructive notice, in other words, that would show that this has been there for a long time, are absent. This was an incident where the lady slipped in an area where no one had slipped before, but it's an area where people, again, going back to my original point, if you're going to walk into an area that's a car drive-through and you're going to walk into it, you have to have the same kind of degree of care that you do when you walk into a planting bed or something like that. There are certain hazards, maybe some seen, some unseen in that area that are going to be problematic, and you have to be on a heightened alert. And the fact that this happens to be a small community bank, and it didn't have a walk-up ATM should change nothing. I mean, it shouldn't be penalized for this. There's no evidence in the record by any expert that says that there's a negligent design here, or that a bank must have a walk-up ATM in addition to a drive-through ATM.
well, it's a question of whether the customer's been invited. Doesn't it go to the customer's status as an invitee? I think that's,
The customer is certainly, and this was the, this is where the argument below got into kind of licensee. The customer is certainly invited to be on the premises, but for a specific purpose. It goes beyond the scope of that invitation, and depending on, if you want to look at it under the, under the invitee, or under the, that line of questioning, she exceeds the scope of her invitation when she uses the drive-through in a way that it wasn't meant to be used. If you want to take it out of that frame of analysis, then we're back to the cases that I've been talking about, where she's walking into this area and she knew, or should have known, that that there could be water. There could be, sometimes one of us has a car with the air conditioner on in the summer in a place for 5 minutes, and there's a puddle of water when we pull away. Someone may walk by moments after and slip on it. And if this case goes to a jury, it's going to be pure speculation about the amount of time that this particular thing was there. And it would set a terrible precedent if we said every drive-in or every drive-through in every bank in the state of Florida, regardless of size, has to take some kind of extra measures to keep people from walking in an area that clearly was not designed or meant to be walked in.
would it be a different question if there was evidence in the record, and I'm not suggesting that there is, but if there was evidence in the record showing that there was a lot of oil or a lot of oily, slick substances around the area, in just like almost pervasive, as opposed to just one isolated, because this case is focused on one particular slick, or whatever you want to call it. Is it a different case if there's evidence of a bunch of different slicks in the area?
I think it depends on the case, Your Honor. Certainly, there can be a case where something occurs often enough, as was discussed earlier, that that at some point the business owner's on notice. Hey, we have these slicks in here regularly. Maybe now we need to, we need to pressure wash more often. But in this case, there's no evidence this has ever happened before. We are very focused on this one slick, if you will, the one area where the plaintiff slipped. There's no indication of how long that was there. It wasn't there when the bank closed, based on the evidence in the record. And if it goes to a jury, it's pure speculation about how long it's there. And I think that's why the trial court cut this off and said we cannot have the degree of inference stacking that the plaintiff is requesting, that this lady saw something 4 days ago, and that something she saw, it required pressure washing, and that something was oil, and that there was no pressure washing. The court, rightly saw that there was a stacking of inferences there, and as I've already made the point, when you go back to just this puddle in any of these foreign transitory substance cases under the statute, or even outside the statute, in a store where you can't tell how long that substance has been there, there's just no evidence that allows a jury to make that determination. It's pure speculation, and as a result, the court was right to cut this off at the summary judgment stage, particularly under the new standard.
If you, let's assume for a moment, is it your position that the plaintiff is the master of her own case, such that if she's arguing one particular theory and she's focused on this one slick and not the repetitive activity or that kind of thing, or even that the statute doesn't apply at all, even if the evidence, there's some evidence in the record suggested otherwise, that maybe she'd have a claim if she asserted a related alternative theory, but it wasn't asserted in opposition to summary judgment, is she stuck with that now on appeal?
There's a lot to unpack there, Your Honor, but from what I think you said, yes, he or
Has she waived
she
this
is,
other position?
Yes, she's waived. The case is decided, is framed by the pleadings. The plaintiff chooses to plead in a certain way, chooses to argue in a certain way at summary judgment. And if there was another theory she could have pursued and may have survived summary judgment under, and she didn't raise that, she has waived that.
Waived or forfeited, I'm not
Or
sure what the difference is.
Forfeited.
Well, either way.
There are a lot of reasons that lawyers go down one path as opposed to another. I think very good lawyers on the other side here went down this path because they didn't think they're going to be able to prove the other. That's what happens in a lot of cases. But if there are no further questions, for the reasons in the brief and the reasons that are argued here today, Capital City Bank would ask that this court affirm the trial court's entry of final summary judgment in its favor. Thank you, Your Honor.
Thank you, Your Honor. First thing I'd like to address is the fact, the assertion that there's no evidence supporting that what she slipped on was actually oil. In this case, there are multiple pieces of direct evidence in the form of eyewitness testimony that supports that this was some form of oil that she slipped on. So first, Ms. Morris, in her own deposition, testified based on her own eyewitness testimony that she believed it was transmission fluid, which is a form of oil. She also stated in her interrogatory, again, based on her eyewitness testimony, that she believed it was a combination of oil or transmission fluid. We also have a picture of it, a color photo. It clearly looks like an oily substance. And then Ms. Angela Wilson, who also observed it with her own eyes, testified in her deposition that she used oil dry to remove the substance and that it had an oil-based look. And so direct evidence without any inferences can get the jury to the point that it was in fact an oil-based substance. This case is far distinguishable from what I would describe as the landscaping cases cited in the answer brief, primarily, well, for a number of reasons, but primarily because in those cases, what is key is that the landscaping is so open and so obvious and not inherently dangerous because the plaintiff actually sees the landscaping area and intentionally steps in it and trips over a tree stump or a tree root, which is obviously something that is observable in the landscaped area. And in the cases that do talk about whether it was intended for walking, in those cases there was no evidence that it was routinely used, which is why the Grimes decision specifically distinguished those cases, even in the landscaping context, where the landscaping area was routinely used for walking, such as this case.
The question here, though, is how far does the bank's duty go to maintain its premises
And it's
here, in particular, this area around the ATM, which is clearly a drive-through ATM. The evidence that your counsel below chose to present evidence in a certain way. It chose to focus on this one oily, slick, whatever you want to call it, slippery. Let's just assume it's slippery in some way, and nothing else, other than they pressure wash from time to time. They acknowledge that there's debris that accumulates. But you haven't your client has presented any evidence to suggest that, to indicate that the bank would have known about this particular one, and there's no evidence indicating that there are a whole bunch of oily areas that were a hazard. So, I mean, are you not boxed in by your own presentation below in opposition to summary judgment?
Well, I think that this court, as far as preservation is concerned, I think this court does have discretion to hold that a party has waived an argument that they haven't made it below. But if I understood your question correctly, I believe you may have suggested that there isn't evidence that they knew about this particular oil spot. But to be clear, the 4 categories of evidence that are proven by direct evidence is the evidence that demonstrates that the bank, or that a reasonable jury could conclude that the bank did have knowledge of this particular oil spot, because the inspection occurred 4 days prior, and it needed.
She didn't inspect. She didn't say that particular spot had oil on it.
Correct. There is no direct evidence establishing that that particular oil spot was there 4 days ago.
Well, it's
But there is
actually the
certain-
opposite, right? She actually says that she did not see oil in that spot, or that she doesn't remember seeing oil in that spot.
Correct, Your Honor. So that only means that there is no direct evidence, because she does not remember. If she remembered, there would be direct evidence that there was oil or that there wasn't oil. But the statute does not require direct evidence. It allows for circumstantial evidence. So it must be the case that the plaintiff can prove the case, can get to a jury even though she didn't specifically remember. If this court requires that she had to have remembered, this court is saying that the plaintiff cannot prove their case by circumstantial evidence. Because in this instance, based on her report, the fact that pressure washing can be used to clean oil, the fact that there was oil, and the fact that there was none of the other items on the non-exhaustive list, in fact that oil would have remained, can allow a reasonable inference. Thank you, Your Honors. If there are no further questions.
Thank you both for your arguments this morning. We have no other cases before us, so we are adjourned.
All rise.